Let's recap the three main methods to get divorced in Connecticut. The first is the traditional one. It is divorce litigation. That's where you file your divorce with the court and you're interacting with court deadlines and court rules and court schedules in order to finalize your divorce. Before I leave the litigation, I like to make sure that you know that there are high conflict litigations and there are low conflict litigations. There are divorce litigations where people never see the inside of a courtroom, and there are divorce litigations where they repeatedly have hearings and maybe even proceed to a full trial. So litigation is most likely going to result in a settlement, not a trial, and that settlement will be achieved out of court. But it's important to know that in all three methods of divorce, it's possible to reach an out-of-court resolution, even if you litigate. Okay, so now let's talk about the two alternatives to litigation. Alternative dispute resolution, or ADR. The two most common forms of ADR, alternatives to litigation, to resolve your dispute, are mediation and collaborative divorce. Mediation and collaborative divorce have a lot of similarities. They both happen outside of court. It's an outside of court process where the goal is to reach a full resolution and then file that agreement with the court for the court to hopefully review and order it and make it official order of the court and dissolve your marriage. They both do that. Mediation is structured a little bit differently than a collaborative. In a mediation, you hire a divorce mediator. The divorce mediator is probably a divorce attorney, at least in my opinion, should be. And that divorce attorney isn't actually acting as an attorney. The divorce attorney mediator is acting as a neutral who helps both spouses reach agreements. That's their job. They give legal information. They don't give legal advice. In a divorce mediation, each spouse should also have their own attorney. Now, that attorney we tend in Connecticut to call mediation review counsel. In other words, those review counsel you will meet with on the side, generally not in the mediation session itself, to get advice on what you're agreeing to. So that the things you bring back to the mediation table, you have the benefit of an attorney who represents you, you're their client, giving you information, advice, insights, takes on what is happening in the mediation, what it means, so then when you reach agreements in the mediation, they're fully informed. It's not that person's job to push you to litigation. It's not that person's job to guide you away from mediation. It's that person's job, your review counsel, to support you in making good informed decisions throughout the mediation. But the thing that you'll want to picture when you picture a mediation table is most likely you, your spouse, and the mediator in the room, and then your independent review counsel on the side giving you advice as you need it and as you're making decisions. Now, at a collaborative, the table looks a little different. You and your spouse each have a collaborative attorney at the table with you. So this is often appealing to people who like the idea of staying out of court, like the idea of a process that's designed to structurally to foster out-of-court agreements, but they don't really want to be their own lawyer in the room. They don't really want to be the one doing 100% of their talking about their position. They feel better with a lawyer by their side. So these collaborative lawyers, when we are in that function, the collaborative lawyer's job is twofold. It's to represent you, you are their client, but also to support the collaborative process itself. So if your goal is to stay in the collaborative process and reach an out-of-court resolution through the process, they're both helping you with that, and they're supporting you in making decisions that are in line with your goals for the future, and they will also want to make sure that you have the concrete legal advice you need to make decisions. Also at the collaborative table are coaches. Frequently there's a parenting coach or a financial professional, and those folks are neutrals, and they're providing information on parenting, on custody, on how to structure financials, on things like taxes and alimony, and how much everyone can afford, and how to refinance the house. And all of that can happen right there in the collaborative process. So those are the three main processes: traditional litigation, which can be either high conflict or low conflict, resolve in court via trial or hearings, or resolve via full agreement; mediation, which is mediator, clients, and on the side, their independent review counsel; or collaborative, which is also an out-of-court process like mediation, but in the collaborative, the lawyers are present with you, along with the neutral experts at the collaborative table. So what's the role of your lawyer when you're trying to decide what process is right for you? Let's talk about this. First, I want you to meet with a lawyer who works at a firm where people do all of the things, where people serve as a neutral mediator, where people serve as mediation review counsel, where people are litigators and trial attorneys and hearing attorneys, where people are collaboratively trained divorce attorneys. You want someone who works with professionals who understand all of these different approaches so that you can get the best possible advice on what approach is most aligned with your goals. I want you to do that before you pick a process. Before you commit to mediating, make sure you meet with a lawyer to make sure that mediation is the best way to achieve your goals. So for example, say your spouse wants you to mediate and you want to do something that your spouse wants to do because you don't want to create an issue for no reason, and you've heard of mediation, it sounds good, but on the other hand, you think your spouse might be someone who tries to hide assets. Well, when you meet with a lawyer, you might find out maybe mediation isn't the best way to go about this. Maybe making sure that you have a full financial picture, maybe that's better accomplished via a collaborative or a litigation. So pick your lawyer first. Choose a lawyer who doesn't have a dog in the fight over what your process is, except for the process that will bring you closer to your goal, that will be the most successful for you. That's the order. And then when you get those insights and information from your lawyer, and you have a good sense of how the timeline might play out in the different things, how transparency might play out in the three different modalities, then you can make a really fully informed decision and feel good about it and be able to look back upon it and know that when you were making the decisions, you were doing it with your eyes wide open. All three approaches to divorce can be excellent. I've seen people have great experiences and outcomes with mediation. I've seen people have great experiences and outcomes with collaborative divorce. I've seen people have great experiences and outcomes with the traditional divorce litigation. The process itself isn't the main thing over whether or not you have a good divorce. The main factor is really if the process is best for you. Now, what do I mean by that? What's your situation? Do you have a spouse who's a person who's forthcoming? Do you have a spouse who is comfortable making commitments and living up to them, that they're reliable that way? Do you have a spouse that is comfortable being in the room with just you and a mediator, for example? Or are you and your spouse more comfortable with a lawyer by your side? There are all sorts of situational factors that assist us in giving you guidance on what the best process is for you. And then how do we define what the best process is for you? Well, we compare the situation to your goals. So for example, say you have a goal of keeping your divorce moving, of trying to conclude it by next summer, or whatever your goal is. Well, based upon certain things about you and your spouse, a different process might be better to accomplish your goal of having a divorce that's efficient in terms of time. So for example, if your spouse is lousy with deadlines, terrible with paperwork, travels a lot, isn't around, well, in an out-of-court process that requires both of you to like exchange documents and live up to your commitments to a timeline might not work well for you if your spouse just isn't wired that way. So I think one of the things that's important to know is that if you have these conversations with your lawyer in advance when you're thinking about a process, it then allows you to talk to your spouse about it and say, look, I really would love to stay out of court, but I really want this to go quickly. And I'm just not sure that given your schedule, that's something we could accomplish. Maybe your spouse will say, no, I want the same thing. And I commit to you that I'm going to keep on task and keep my commitments, right? What you want to know is your lawyer's advice based upon you, your spouse, and your goals so that you can really make the best possible decision to achieve those goals. That's why I get a little bit nervous when people say, well, this process is inexpensive, or this process is more amicable, or this process is faster. Because the things that make a good mediation, if they're not present, it won't be faster. But if they are, it probably will be. So get experienced help who knows all the processes, who knows the variables, who can ask you the right questions about you and your spouse and how you kind of operate in the world so that you can really find the right process for you. So what happens if you got it backwards? What happens if you didn't meet with counsel who knows about all of these methods and can give you the best advice, and you wind up in a process that isn't the best one for your goal? Well, let's talk about it. Okay. Say you wind up in a litigation and you really wish you had mediated. Well, during your litigation, you can always invite the other side to mediate. You can even invite the other side to press pause and go to a collaborative table. You can use a targeted mediation to resolve financials. You could bring in a co-parenting counsel to help you with your parenting plan. So all is not lost. If you're in a divorce and you really wish you had mediated and you'd like to keep it out of court, we can use mediation tools or other ADR tools to try and resolve your litigated divorce out of court. What if you're in a mediation or a collaborative divorce and you don't think it's the right situation for you? You went along with it because it was your spouse wanted it and you wanted to be amicable about your approach to the approach. What do? Well, sometimes you end it and try a different process. Sometimes mediations turn into collaboratives because they need a little bit more support and structure. Sometimes mediations wind up in litigation because somebody just can't move it forward and they really could benefit from a court deadline to make sure that the divorce progresses. All isn't lost. There's another process. You will still get divorced. But please, if you haven't started your divorce yet, let's try and get it as right as possible the first time. Meet with a lawyer before you pick your process.